everyone. Good morning again. We'll go ahead and get started. I realize that it is warm in here. We have facilities coming up. They're going to lower the temperature, so we'll keep an eye on it. If it remains hot, be assured that we are remedying the situation. Good morning, and thank you everyone for being here. I am really excited about the day that we have before us. My name is Betsy Dobbins, and I am the Submissions and Symposium Editor for this year's Law Review, who is hosting this event for all of you. We have an amazing lineup of speakers and a great room of people who are really passionate about the topic today. So I think we're going to have a great dialogue about the legal rights and needs of youth in our community and in the state of Florida. Just a couple of housekeeping things. We will be taking a couple breaks throughout the day for bathroom and that sort of thing. Please feel free to come and go through the back doors if you need to take breaks outside of those. There are bathrooms that are located down this hall, pretty much right behind this room. There are also bathrooms around to the far left of the building if you go out these doors and follow the hallway to the left. And there will be people, especially the folks in the very back 2 rows, can always point you in the right direction if you're not sure where to go. If you guys have any questions, I'll be sitting up towards the camera, and feel free to search me out as well. With that being said, we'll go ahead and get this show on the road because we have a lot of great people to talk to you and to talk with you. Dean O'Guiney is going to be offering some opening words and get us off on the right foot. Thank you.
Thank you, Betsy. And I want to echo your thanks to the participants in the symposium and our honored guests. We are delighted to have you here. I thought about what I would say to you all, and I promise to keep my remarks brief because you have such a scintillating program before you. But I'm an old corporate / transactional lawyer guy. I never took family law, never practiced family law. And so I figured, well, what am I going to say that to this crowd? So I did what every self-respecting dean would do when they don't know the topic they're supposed to talk about. I went to Google. If there are any LP faculty or librarians in the room, you can close your ears now. And I came across a fascinating report from the University of Florida Legal Representation of Dependent Children. And I was very struck by the opening words of the report. It says, fewer than 10% of Florida's neglected, abused, and abandoned children have access to attorneys to represent them in the courtrooms where their fundamental rights are at stake. And it just really grabbed me. I couldn't believe the scale, the magnitude of the problem. And it went on to say, even given that fewer than 10% of these children have rights to attorneys, have access to attorneys, that the likelihood of any particular child being able to have his or her own attorney is based in the largest part on the accident of geography. That if you are in South Florida, especially in Palm Beach County, you have a decent chance. But for children in the rest of the state, the prospect of obtaining counsel ranges from slim to none. And that, you guys will probably already know this, but for the rest of us who don't have the background, it's a very alarming and disturbing fact. And so I want to thank you for drawing attention to this issue and the panoply of rights and services that these children desperately need but don't have. And I'm delighted as I looked through the symposium, so I then went to the agenda and I said, well, I want to make sure that while we have an appropriate focus on scholarship and the things that a law review traditionally does, that we are going beyond that to focus on how do we tackle the problem. And I'm proud to say, and I think this is a testament to the staff of the law review and the students, that that is in fact what seems to be the agenda for today, that we're not just talking about the issue, we're talking about how to solve it, how to come together in collaborative ways to help fix it. And that we are not just talking about legal rights without context, that we're talking about it in the context of a holistic process So I was very happy to see that one of the items on the agenda is how do you address the mental health needs of these children. So again, I can't say enough about how proud I am of our students, the staff of the Law Review, the fact that you are all here to tackle this very important issue. I wish you Godspeed, and unfortunately, I have some other commitments during the course of the day, but I promise to return as often as I can to just sit down and partake of the discussion. So thank you very much again, and anything that we can do to help you, we're delighted to do again. Kudos. Thank you.
For continuity today, we have the wonderful Beverly Brown, who's going to be acting as moderator and just introducing the speakers and their topics before each separate session. She is an amazing advocate in this community, and her work for students here in Jacksonville, in Duval, Clay, and Nassau County is just unparamountted. So without further ado, Beverly Brown.
Good morning. Our next speaker is Robin Rosenberg. She's going to be talking to us today about promoting the best interest of children by empowering legal defense of their parents.
Gotta invite Robert too, because we're together.
Oh, I'm sorry, Robert. And Robert Latham. Robin is Deputy Director at Florida's Children's First, and Robert is Supervising Attorney at the University of Miami School of Law.
Good morning, everyone.
Good morning.
Well, I would say that the dean stole my thunder. The report that he read to you was a report that Florida's Children's First issued with the University of Miami. And our organization fights for the rights of children that are entitled to services from the state. And we try to make systemic reforms, systemic improvement for children, our primary mission being to get more kids lawyers. And we are just in the process of undertaking an update to the 2012 report because there have been significant changes in the access of children to attorneys to having attorneys in the dependency system. And we're figuring out our AV.
Yes.
So as I am a children's rights lawyer, I approach the work of what happens to kids in our child welfare system So, I approach our work by looking at what's happening, what's in the best interest of children. And that is not the topic for our presentation today. Well, the best interest of children is our topic, but focusing not on the children's lawyers, but in this case, on the parents' lawyers. So I had the opportunity to argue about ineffective assistance of Parents Council before the Florida Supreme Court the first week of February. And when I asserted that children suffer when their parents don't get good counsel, the Supreme Court looked at me like I had three heads. Clearly you mean the children's lawyers. And I said, no, our issue really is the effectiveness of parents' attorneys. And so that's what my part of our presentation is, to convince all of you that if you care about children in our child welfare system, then you should also care about how their parents are being represented. So as we get started in this, I'd like a show of hands for those of you who have done any work in the child welfare system. Representatives. Okay. Great, a lot of you. So sit on your hands for a minute. And the rest of you that didn't raise your hand, if you think about child welfare, what comes to mind? What are the issues that come to mind? What do you hear about in the news if you hear about child welfare? Anybody? We hear about, okay, now where's the clicker? Okay, did anybody hear this is a national story? Phoebe Johnchuk, her father, threw her off a bridge into Tampa Bay. So everybody's heard of that child welfare case? This is Jenica Randazzo. Her uncle beat her to death with a tire iron, also killed his mother, her grandmother. She was placed in her grandparents' home after her mother couldn't care for her. She was removed from her grandparents' home and then placed back in not too long before she died. And how many folks have seen the Miami Herald piece? Oh, that's interesting. Half of the Miami Innocence Lost, right? The Herald did an ongoing piece. They published in a physical newspaper, but continue to update their database of children who are injured who have died, who were known to the Department of Children and Families. Okay. Is this common? Is this typical? Right? We hear about the really tragic cases. We hear about the child deaths. And so I think in the minds of many people in the public, what we think about child welfare is that parents are bad, they do criminal acts on their children, they hurt, they kill children. And we have to protect children, they're victims of their parents. So we have, I think, in the common understanding of child welfare, good children versus evil parents. And we've essentially set up a criminal-like system for the child welfare system, which Robert's going to talk about in more detail. But the reality for most kids who are involved in the child welfare system is not that they will be seriously physically injured or that they were when they came in. The national data shows us that 75% of children come into the foster care child welfare system because of neglect. Just 17% have suffered physical abuse, and about 9% have suffered sexual abuse. So that concept of evil parents hurting their children is not the typical case coming into the child welfare system. Florida has very detailed child maltreatment codes, and there are over 20 codes that are verified if a child has been accused, if there's an accusation that the child has been neglected. Thank you. So we'll see at the top of that pyramid, just 4% of the children that come into care have been the victims of sexual abuse. 8% have been the victims of physical abuse. 22% is a generalized neglect, but if you add in the bottom two categories of substance misuse and family violence, threat, and harm, that adds up to basically the 75% of our children that are neglected. Kids come into care primarily because their parents have problems. And it's what happens to them when they come into care that motivates me to say their parents need better lawyers. And I want to tell you about two of the families that I personally worked with that led me to that conclusion. I want to talk to you first about Joey. Joey was 3.5 years old when they brought him to my house on a Friday afternoon. He was a little quiet, he was clean, he was healthy, he was well dressed. He was a little shy when he walked in, but within 4 or 5 minutes, like every other typically developing young child, he was on our spring horse. It's in our living room, it's the first thing the kids see, and he was bouncing away. In another 5 or 10 minutes, he was off with my children, playing in their room, playing with toys. He had a great afternoon. We had mac and cheese for dinner, he had great dinner, he had, he was doing okay. It was Joey's first time in care. Joey came into care because his father was violent and beat his mother's car with a baseball bat. The police came and the determination was made that Joey's mother was not able to protect her children from her husband. Joey was 3.5, his sister was 2, his baby brother was 1. His baby brother has spina bifida. He went to a medical foster home, and for whatever reason on a Friday afternoon, the child welfare system couldn't find a foster home to take a 2-year-old girl and a 3-year-old boy. And my foster home can only take boys over the age of 1, so he came to us for the weekend. So Joey was fine during the daylight, and then when it was bedtime, my kids went to put pajamas on, and Joey wanted to put his sneakers on, because it was time to go home. You know, if it's bedtime, and you know, he had fun, he had a good play date, he had a nice dinner, but it was time for bed. And when I explained to Joey that he wasn't going home, he climbed up on my couch and put his head on the back of the couch and stared out the window and cried, sobbed for his mother for 3 hours until he exhausted himself to sleep. Joey had never been separated from his mother before. He wanted to go home. He was ready to go home. And because of the circumstance that his mother found herself in, he could not go home. And at least for that weekend, he was in a home by himself without his sibling. So let's talk about what happened to Joey during his journey in state care. My husband and I really just do respite, short-term placements for children. And when they asked us to take Joey on a Friday, we said, you know, that's fine, but by Monday you will find a home for him and his sister, right? Because you have to do that. They have to be together. So they found a foster home for Joey. So we know he was separated from his mother for the first time in his entire life. On Monday, they were going to send a transporter over to take Joey to his new foster home, and I said, no, I'll take him. There's no need to take a stranger to drive him somewhere. He's already traumatized. And we went to the new foster home. He was reunited with his sister there. Very lovely people that didn't speak English. Joey's language is English. The father spoke passable English. The mother didn't speak any English. They were very excited. First time foster parents had a great room ready for him, ready to go. He couldn't talk to them. They put him in childcare, and good high quality childcare that didn't speak English. And fortunately, we were able to get Joey an attorney, and she was able to get him a therapist who spoke English and get him moved into a daycare that spoke English so that he could have someone to talk to process his trauma. 9 months later, Joey and his sister were reunified with their mother. 9 months of what his mother had to work through to get him back because she was a victim of domestic violence. So imagine those of you that have had little children or currently have little children, what they go through every day. Half the kids in our foster care system are like Joey, age 6 and under. Those are the children that we have separated from their parents. That's the age ranges. You can see 13% of them are under the age of 1, 38% between the ages of 1 and 5. Half of our kids in care are little children who are separated from their parents. The big kids that come into care suffer as well. I want to tell you about Tina and Max. Tina and Max's mother has a serious and persistent mental illness. This picture is a drawing that she made that she sent me a copy of. The reason Tina and Max came into care was because their mother had to be hospitalized when she decompensated. Her family was out of state. She had no one to take care of her children. Her children came into foster care only because of her physical inability to care for them. Now, at her worst, on her worst day, with a very serious mental illness, she was a good mother to her children. Tina was 11, Max was 9 when they came into the foster care system. Tina was really angry at her mom for decompensating and for causing them to come in the system. Max was oblivious. So when they were brought in, the kids were fighting. Tina kept saying to Max, why don't you understand? Don't you understand? This is all mom's fault. They were fighting so much that the foster care system decided that the children would be best off if they were separated. so that they could both handle their issues separately. Of course, let's talk about what happened to each of them in care. At 9 years old, Max was placed into a therapeutic foster home, which he needed because he has mental health issues. Again, a place where English was not the primary language of the home. I'm not sure. Totally separate cases, same issue. He had a lot of school issues, but his foster parents did not participate in his schooling. His IEP was a mess. And when his mother, who was very active in making sure her children's education and welfare was taken care of, when his mother tried to go to school, they didn't want to talk to her, even though she had educational rights. His mother was able to get an education lawyer to represent her, and the foster care system almost didn't want to let her do that. They couldn't understand what rights she had to have a lawyer for her own kids. But no one else in the system was advocating for their education except for their mother. Max misbehaved, imagine that, under the circumstances that he was in. And his foster parents, who had several other children on medications, promoted Max taking psychotropic medications. What they didn't know, but his mother knew, was his history and medical condition and heart problems. And they were going to truck along and get Max on psychotropic medications, and his mother had to fight tooth and nail to attend to require cardiologist appointments and to make sure that her son was safe if he was taking meds. No one else would have done that for Max except his mother. Sibling therapy was ordered because the kids were separated right up front. It was never provided. And that's a good outcome for Max. Nothing really bad happened to him in care. Nobody injured him, but that was his journey. His sister Tina went to the first foster home she was in. Tina was a straight A student. She was a good kid, had never been in trouble. She came into care over the summer, and her mother took her to the foster mom, took her to the library every day and dropped her off. Every day, including days when the library was closed. And Tina had to call her mother to come get her because she couldn't reach a caseworker or anyone else. So then they moved her to another foster home, awesome lady, in the next county. Tina was in Hillsborough. This foster home was over the line in Pasco County. She got into a great middle school. She made friends for the first time in a long time. She was able to be reunified, but mom decompensated again. Tina did what she was supposed to do. She followed the safety plan, called the people she was supposed to call, but they had changed the safety plan and didn't tell her. So it appeared as if she wasn't doing what she was supposed to do. She was removed again. And this time she was put in the shelter, in a shelter with kids who routinely did drugs, who ran away, who had adult boyfriends. And guess what Tina started to do? She started to fall in with the crowd. At first, her mother insisted that she be transported back to her school across county lines. And that happened for a while, until the judge decided, no, we've had enough of that, and moved her into the local high school for the shelter, which she hated and refused to attend. And then finally they decided to move her into a therapeutic foster home, but the only one they could find was 2 hours away. Tina's mother had unsupervised visits, unlimited unsupervised visits, because remember, the only reason she didn't have her children was because of her mental illness, which she was fully compliant with her course of treatment, but 2 hours away, crappy car, fighting every time to get gas money to be able to go down to see her children. Typical course of stay. Tina's mother went to the shelter to help her pack up to move from the shelter to the therapeutic foster home. The only thing Tina had on the walls of her room in the shelter were these certificates of perfect attendance. When she had been at her original high school, her goal was to have perfect attendance through the whole year, enter into a drawing to win an iPad, and keep her grades up. And that all went down the toilet with the placements that she was in. Daycare is no bed of roses for children. They experience multiple placements. They lose their educational attainment 3 to 6 months every time they move placements. They can suffer ill health effects, increase the chance that they'll be prescribed psychotropic medication, and be placed in places where they're with kids who have behaviors that they didn't come into care with, but it's pretty easy for them to pick up. She had never run away before. So many kids ran away from her shelter that the police didn't even start looking for children until 48 hours after they went missing. Her mom didn't know that. Her mom spent 12 hours straight until she found her. Her mother found her. The police weren't even going to bother. Oh, the kids run away from there all the time, they come back. And they lose people and things that are important to them. So the journey through care for children is not an easy one, even in the best of circumstances. Most kids who come into care have a goal of reunification. We plan from the outset that kids are going to go home. Yet, we don't work to make that happen very successfully. What we do is we give their parents a bunch of tasks and let it go, expect them to complete them. Very typical tasks: to maintain housing, employment, get evaluated for substance abuse, and if you need it, get the treatment. Take a parenting program, submit to random drug screens, submit to domestic violence screenings, and follow the treatment. Undergo family counseling, and have no new law violations. Typical, on top of what you need to be doing as a parent, which is to be visiting your child, participating in their healthcare, participating in their education. So we set up fundamental, monumental tasks for parents. And then what? Do we help them? No. This is a review that the Florida Mental Health Institute did of looking at case files. And in this particular measure, just looking at how well the caseworker is engaging the parents. And you can see they've improved from 68% to 76% for moms, and all the way up to 60% for dads. So a third of the time, they're failing and trying to engage to help the parents do what they need to do. Well, if the parents can't do what they need to do, they're not going to get their kids back. And who's going to suffer? It's the kids. So if we know half the kids that come into care are reunified within 12 months, the median length of stay for those children is 9 months. So half in are going to go home. And how are we handling that and helping that either speed up, helping that speed up for the ones that are going to go. If they don't get home in that first 9 months, then the chances are pretty good that they're going to stay much longer, at least 18 months. And right now we have 420 children who are supposed to be reunified, who have been in care away from home for more than 2 years. They should be going home. And then there are kids I'll call the stuck kids. 2 years is pretty bad. We have 3,000 children in our foster care system right now who have been in care more than 2 years. And the things that I described to you that happen to those children just get compounded the longer they stay in care. Half of those 3,000 children have not had their parents' rights terminated. Our system is not operating efficiently. That's a very sad way. So it's not a good place for kids to be. It sometimes is a necessary place for children to be, but we have to be able to do better. And we are lawyers, and we think lawyers are part of the solution. So now I'm going to turn it over to Robert.
See how this works. Okay, so what Robin is talking about, I mean, I was moved, right? I've heard that story before, and I get teary-eyed every time I hear it. We need a culture change. The lawyers in this room, you are part of that culture change because the culture as it exists now has created certain structures in the child welfare system. We're going to learn about this. I'm sorry, Betsy, how long do I have?
You have 40 minutes.
40 minutes, okay. The culture we have created over the last 30 to 40 years has created certain structures based on certain assumptions that she started with. Those news stories have pushed child welfare policy a lot. So the question is going to be, how do lawyers and laws actually contribute to the things that Robin just described? So in a typical child welfare case, there are actually 5 lawyers in the room at least. There's sometimes up to like 10, depending on how many parents are involved and whether the agencies bring their own lawyers and other people bring lawyers. So here are the 5 lawyers usually that are in the room, depending on where you are. So there's going to be a state attorney prosecuting a case. There's going to be some kind of guardian ad litem best interest lawyer advocating for the best interest of the child. There may be a child attorney, but we heard at the beginning, probably not. The parents are going to have attorneys, but they did not always. That's a relatively new intervention in the last 20 years. And then the judge, presumably, is a lawyer. In Florida, we require our judges to be lawyers, thank goodness. So we have all of these people. Doesn't always help. We have all of these people, and they're all doing their thing. And in a traditional kind of Civ Pro kind of way, it feels right. Like everybody's got their job. It should just all balance out. Except that that's not exactly what happens. And we're going to go through why. So what we did for the kind of empirical part of our project is we're looking currently at how those groups of people, how the lawyers and the lawmakers and the policymakers actually view the child welfare system. You can see it written in the things they do. We're going to talk about that. So we look at the appellate courts, we look at the legislature, we look at trial courts, and we look at lawyers. We take how they view the child welfare system versus the realities of the child welfare system, put them together, and we realize we have huge problems. And the problems are predictable if you just step back and look at the disconnect. So, for those of you who are not child welfare attorneys or have not studied child welfare, this is the procedure. Think of criminal procedure. It is a very criminal procedure system. It starts all the way on the left-hand side of my chart here with a shelter, which is like equivalent to a criminal arrest. There's something that's happened, and the kid needs to be removed, sheltered, removed from the parents immediately. So this is a probable cause standard. It's a very, very low standard. There's going to be a judicial review of that within 24 hours, 48 hours, 72 hours, depending on circumstances, things like that. Then you move to an adjudication, which is your trial. It's a civil standard, so it's just preponderance, which just means, well, the parents probably abused, abandoned, or neglected their kid. Probably. 51%. More likely than not, that gets your kid placed into foster care out of home indefinitely. Right? That's scary already. All right? Or in a criminal trial or a criminal case, you are convicted, and then what comes next? Sentence. Yay, thank you. So you're convicted and then you're sentenced. We have the same thing in child welfare. You are adjudicated dependent if you're the child, but family adjudicated. And then there's disposition, that's what we call it. What are we going to do with this family? Are we going to put the parents in a case plan which has all the tasks? Or are we going to send the child to a father who is uncharged and lives in Nevada? We'll do that. We have lots of options. For the most part, it's case plan. They're placed under a case plan, and then we enter this loop in the middle, and I apologize, that should have little arrows saying this is the indefinite part. This is the spiral. You get a case plan, which is a document, 50 pages sometimes, has a bunch of tasks in it. Every 3 to 6 months, doesn't really matter how often, but it's 3 to 6 months, you will have a judicial review in front of a judge. This was an innovation of the child welfare system in the past 30 years. We will have a judicial review. A judge will have to review your case. Every year or so, another innovation, we will have a permanency hearing where the judge has to decide which one of these paths, you're going to go down. Is this going to be a reunification case? Are we going to shoot you out towards adoption? Is it going to be a permanent guardian, which is you're going to live permanently with somebody, but your parents will still have rights? Florida has this fit and willing relative, other states do too, I guess it's international, nobody ever uses it. And then number 5 is called APWA. It used to be called long-term foster care, right? But that sounds horrible on paper. You don't want to say your goal for a kid is long-term foster care. So now we say their goal is APWA, and that doesn't mean anything unless you're like Swedish, it means apple. So congratulations, we now have a meaningless word for the goal of letting kids age out of care. Yikes, you can feel the policy fingers all over it, right? We just have to hide it because it's so distasteful. If you're going to go down the adoption track, then there needs to be a TPR, and that's where clear and convincing evidence. Finally, you get something close to like a real trial. No offense to attorneys, but like now you actually have to prove it without hesitation. Now, the reality is that this process is very, very loaded, and we'll get to that. So how do the appellate courts view this? We started logging holdings. It was a lot of fun. Every holding from 1951, when the modern child welfare courts were created in Florida, and we've got up to 2005. I've been working in Florida since 2007, not much has changed, so I'm comfortable with these numbers. We looked at the posture, we looked at the case, we looked at the argument, the outcome for the parents. What do appellate courts think the child welfare system looks like? To them, it is the TPR system, the termination of parental rights system. That's what gets appealed. Appellate judges see TPRs all day long. That's what they do. 47% TPR, 27% dependency. There's a bunch of default cases, parents that didn't show up to court exactly when they were supposed to. The child welfare system actually has 4 opportunities for a parent to default. 4, and it requires personal appearance. The parent who probably doesn't have a car, because we know the overlap between the child welfare system and extreme poverty, doesn't have a car. If they have a job, they can't take off. They don't have my job, right? I can just leave when I want. You leave one day at their job and they get fired. But regardless, with 4 opportunities where they have to show up personally, can their attorney show up for them? No, they have to show up. So, and this has been over time. It used to be that the attorneys could show up, and no, that wasn't good. They have to show up personally. That tells you where the bias is already. 2% of them are reunification cases so far. 2 of them are shelter cases. Those are really rare. TOS is closing a case out. The only time that really gets appealed is when a parent got a case plan and then the case gets closed out with either a relative or another parent who wasn't on a case plan. And the parent's like, oh, hang on a second, you gave me a case plan and you took it away. You gave it to me and you took it away. That wasn't fair. Like, even in contract world, we wouldn't do that, right? But in child welfare world, we do it all the time. So if I put that chart right here on top of our little Doohickey chart, right? What do you see? You see that the majority of the holdings are about dependency cases, how kids get into the care, or get into the system, and TPR cases, how they get out in one very particular way. Look at what's not really all that litigated. The stuff in the middle. Case plans, dispositions, what's happening in that judicial review phase, that stays in the trial court. We don't have legal mechanisms to challenge when things go wrong in that setting, which is what Robin was talking about. All right, what kind of questions are appellate courts asking? Well, they're asking at the front end, is this the type of case that needs to be here? They're asking at the back end, looking back over the case as a TPR, they're asking themselves, well, did everything happen like it was supposed to? Did we provide this parent with due process? At the end of the TPR is where they're asking, years, you heard her, years, sometimes later, they're going to do a complete review of the last 2 years, 3 years, 4 years, whatever, and ask that parent get all the right things checked off of the list. You can already feel the problems, right? Why not solve problems when they happen as opposed to pushing them off into a TPR trial? All right, what about the legislature? All right, we looked at legislative amendments, and you kind of see the same thing, really heavy at the front, really heavy at the back. They keep adding over time various ways for kids to get into the child welfare system, keep expanding the enumerated grounds for dependency. If you've never read Chapter 3901, that's the definition section, harm, there's this giant thing that's multiple pages long with all the ways a kid can get hurt. It's pretty depressing, actually. But there, it's enumerated, and then it's like, and everything else that even is anywhere close to it. So we're very clear on how they get in. And then TPR, at that end, we have like 15 to 23, depending on how you count, TPR grounds in Florida. And some of them are crazy. Some of them are so complicated that they have never been used, but the legislature loves to keep adding them because they believe that by adding more TPR grounds, we'll get these kids out of the system. We won't have them in the system anymore. But it hasn't proven true because they're coming in for neglect. They're not coming in for the extreme things that you can add in. They're into the TPR grounds. And then once they're there, they're getting stuck, not because there aren't enough ways to TPR the parents, but because there aren't enough places to send them to, adoptive parents to take them, or efforts to get the kids back to the parents where they need to be, right? So we have innovated at the beginning and at the end. We have not innovated in the middle. And then you're gonna say, but Robert, look, judicial review is pretty big, right? Well, yes and no. The things that got added over all those years were in fact documentation requirements. So judicial review, that hearing that happens every 3 to 6 months where you go in front of the judge, keep adding things that have to go to this package that gets handed to the judge. So school records, medical records, mental health records, efforts, this, that, other. So the packets now, the judicial review, social studies reports, whatever they're being called in Florida, actually come up to like 100, 200. If you have multiple kids on a case, the packet can be in the hundreds of pages. They're trying to read that? No, nobody reads it. But that's the due process that the legislature has created. the legislature and the appellate courts have pretty systematically deconstructed the procedural due process you would normally find. So can a parent get a default against the state if the state doesn't do what it was supposed to do? Oh, no, because that would be bad for kids. I actually agree that would be bad for kids. Kids shouldn't go home to a dangerous environment because of some kind of procedural error, right? But if you push all of the procedural protections into the case plan of the judicial review and then provide no way of enforcing that, then you basically just stripped out everything. And we're gonna get there. So the legislature, where do they focus, the beginning and the end? And I talked about what kind of amendments are. What are they asking? The legislature is clearly asking probably about 4 questions. How do we protect kids from like those people? You can hear it in the discussions. Kids are suffering and these horrible parents are doing horrible things. But it turns out that 75% of the parents are just accused of neglect, which is very, very situational. The legislature clearly is never happy with DCF, never, right? Because they keep seeing all these things in the newspaper and they're like, why haven't you solved this child abuse problem yet? Which is impossible, so just so we know, right? So they also want to reduce the backlog of kids, both because it's the right thing to do, but also because there's federal money about adoption, so there's all kinds of other things going in there. And then finally, how do we minimize the costs? Because child welfare system is, do we know the number? A multi-billion-dollar system, and it's a huge number. It's way bigger than you expected. It's a huge, huge, huge industry, right? So how do we minimize the cost to the state? How do we draw down federal funds most efficiently? How do we make sure our reporting requirements are met? Great. All right, what do trial courts do? See, now it's not a valley anymore. Check it out. So what I did was, this is for the purposes of this presentation, this is a 10% random sampling of all of the pending court dates in Miami. So it's where I am, so it's the calendar I had in front of me. I went through, I counted them, check it out. If you multiply by 10, let's assume that this is a representative sample, multiply by 10, there's like 800 kids pending JR, judicial review. Right? Look what they're not pending. They're not pending TPR. They're not even pending trial or dependency. They are pending status hearings and judicial review hearings. Those things happen. That is the bulk of the work. Though the trials feel really, really like cumbersome for the attorneys doing them, turns out you spend the most minutes of your day reading judicial review packets. That's what you do. So now the question, how are lawyers functioning in this? And this is what we want to know, because you're going to go out and be a lawyer, like, okay, well, if I'm going to do this job, what is it going to look like for me? Well, here's how they function. We always start with the money. The lawyers get paid to do this. For some of you who have never seen this chart before, these numbers before, you're going to be appalled. Ready? For a dependency case, an attorney gets $800 at the end of the trial. Okay, $800. They then, for each year that they are on the case, get $200. $200. Comes out to $1,000 in the first 2 years, basically. If a new kid comes in and you do a new trial, do you get another $800? No, you don't. Sorry, you are still in the $200 bill. All right, if your case goes to termination of parental rights, oh, well, then we will actually give you $1,000 for that. So you can get $800 plus $200 plus $1,000 now. Why is that number higher than the 800 number? Yikes. All right, $200 for every year after that. Now, it turns out that there's constitutional provision or something, there's some case law, that says that if it would be confiscatory, if it would basically steal the attorney's time to pay them that amount, the attorney can bill for what's called an extraordinary rate because the case is extraordinary in some way. The idea of flat fees is that for most cases, this will even out. Some of them will be so easy that $800 is like you do it in 2 minutes. Some of them will be so hard that, well, that's what you get for having all those easy ones, right? So they can bill for it if it would be confiscatory. The rate is then $75 an hour, which is not bad. I don't think that, in lawyer terms, it's horrible, right? But, you know, state attorney, type of government attorney, $75 an hour is pretty good. When does it become confiscatory? Well, it's not clear. The $800 and $1,000 breaks at about 10 hours. That's when your $75 an hour really pushes you over. And then in your judicial review years, it's about 3 hours. You spend more than 3 hours that year. Let that sink in too. You spend more than 3 hours that year, then, oh, you've done a lot. All right, so what do? We actually pulled from the Justice Administrative Commission their entire billing records. The attorneys have to submit billing records. The private attorneys, does not include the state agency known as regional counsel, which gets a flat amount or a fixed amount and then has to represent a bunch of parents. This is all the private attorneys that take the second parent that comes through the door. So those guys have to bill, and they have to bill like traditional attorneys. So look, we get to see everything they do. All right, we've only had this data, by the way, for a week, so we're really excited about it, but we haven't really done much with it. So I'm going to give you some very descriptive statistical information about this. So how often do attorneys actually bill for extraordinary? This third column is the order on disposition. This is how you bill when you just did a dependency trial, that preponderance trial at the beginning that gets kids in. That little tiny red sliver at the top that you can barely see because it's 1% is how often the attorneys spent more than 20 hours and thought it was worth billing, or more than 10 hours on their dependency trial. Whoa. To compare, look at the second to last column. That's an order granting a termination of parental rights. This is, if you bill using the order to terminate parental rights, then it's probably about 20%, more like 17%. Those are real trials. We know those are trials because you can't really, for the most part, get an order granting TPR unless they default, but most people don't really default at their TPR. So, they're not doing trials, right? I mean, we'll figure that out real fast. The numbers are pretty obvious. The difference between an order granting a TPR and denying it doesn't seem to matter. You put in a lot of work regardless. What are they getting paid for? Uh-oh. The second one, the one they're doing no work on, is in fact the bulk of the money. So the bulk of the money goes to them after the dependency trial. Because every parent defaults or consents, they take a plea. You don't have to do a lot of work. You can crank those things out. You can push them into judicial review world and you're done. Remember, it's a $200 versus $800 in judicial review. So actually at $200 a pop, for the most part, that third column is what's happening. You can see a little spike over here in order granting TPR. They get paid for that. Look what they don't get paid for. Order denying TPR. When they win, somehow it's so easy to win, when you win, right, that you don't even bill really extraordinary for it at all. It's probably because prosecutors have discretion to bring a case only when it's right. So if a prosecutor is green and doesn't know what they're doing, they bring a bad case, you can usually probably convince a judge to toss it really fast. A good prosecutor is not going to bring a TPR because there's not really the incentive to bring it until you can win it. So that's my theory. We'll see if that pans out. Average invoice per disposition. The colors, by the way, are circuits. So the little zebra stripes are the circuits. Average invoice per disposition, order on judicial review. See the middle? See the valley? On average, they're billing far less in the middle than they are at the end. It makes sense because lawyers like to do trials and they get really excited about it. Lawyers don't like to do status hearings. They don't get excited about it. They show up, they're billing far less. If you were curious, and I certainly was, what was the most anybody got paid for any of these things per circuit? So there it is. Even if you try really hard, remember we're in the $35 million range over here for everybody, right? So even if you try as hard as you can, this is the most anybody ever billed for any of these things. So there's the one dead in the middle, that's the biggest one, that blue blob right in the middle. That's a person who managed to close out a dependency case successfully, mind you. This was the biggest one. It's $48,547 at $75 an hour. I got the billing records. This is part of our project. That attorney every night spoke to her client for 1 to 2 hours. I happened to know that case because I was on it for a while. The father had severe mental health issues, severe paranoia. Every night, she spoke to him basically before he went to bed to convince him to get up the next day and take care of his kids and do what he needs to do, and this is what's happening to you, and this is what it takes. Every single night. And you can see it in the billing records. She billed every single day. 1 to 2 hours, sometimes multiple times. To me, she got those kids home successfully. The father's mental health problems were not actually a threat to the children's lives. He was paranoia, black helicopters and tinfoil, but otherwise no danger, no violence or aggression. So kooky, but not dangerous, but makes everybody uncomfortable, right? We'll get to that. To me, she earned it. She convinced the judge and everybody else, and the father, that he could do this. Right? Now, what litigation expenses are the attorneys claiming? Because they pay for their litigation expenses out of the same pot of money. So, like, if you look at it, I don't want to get into it too heavily, but mental health investigations and mental health evaluations is what we would expect. So that's the purple one, and it goes up the closer you get to TPR trials. Okay, depots go up, everything goes up. But what I want you to notice about this, for those of you who remember high school, check the units on the graph. That's top one is right above $100,000. Remember what we're talking about? We're talking about $35 million. Attorneys use due process claims $100,000 out of $35 million. For the most part, they are not getting their own evaluations, they are not doing depositions, they are not doing anything except traditional legal work that involves filing motions and showing up in court. That bothers me a lot because they're just trusting the state's experts in a way that I know is not always legitimate. When you put the litigation expenses in there, then suddenly you can't even see all the other stuff, right? Now we're up to $40 million for the disposal. All right. Now this is the project. This is what we're going to be working on in the next few months. This is 2 attorneys. This is 2 TPR trials. This is how they spent their time on average, or proportionally. So I'm not telling you how many hours they spent. What I am telling you is that the attorney on the left spent approximately 5% of her time reviewing correspondences. Can you see the difference? Does anybody have, so take a second to take it in. Does anybody have a theory about which of these won and which of these lost? Trial prep on the right is huge, court time on the right is huge, trial prep on the left is less, but the person on the left spent more time talking to witnesses. They spent about the same time reviewing documents and pleadings. One on the left spent a lot of time drafting things. Who won and who lost? Anybody? The one on the right won? Yeah, that's everybody has said that to me. Guess what? Well, turns out the one on the left won. The one who spent more time talking to the parties, being involved in the case, she was the reviewing correspondence's emails. She was on every single email the department sent. Every reply all was with her on it. She was interjecting herself into it. She was engaged. She was basically negotiating the case out at every second of the case. She was very invested. I can tell you I was also on that one. I picked it at random. Turns out I was also in this case too. So I know her. She was engaged. She's a powerhouse. This difference may matter. We don't know yet. I'm not going to tell you that everybody who emails a lot wins their trials, right? That's not the lesson. But I am going to tell you that we are going to be looking at what behaviors actually lead to good outcomes. And I have a theory that when an attorney is actually invested, much like the woman who talked to her attorney or talked to her client every single night, when the attorney is invested, the outcomes are better. All right, so what's the problem? That we don't invest in the part we need to be investing in. We had the loop, and we had the up. How am I doing?
Good, good.
I'm doing good.
Yeah.
So what in the literature it's called the due process donut hole. I like that term. In the literature, there's like a million things talking about how reasonable efforts requirements are stupid. They lead to bad outcomes. If you wait 2 years to look back instead of solving problems that need to be solved, you will wind up punishing kids and hurting kids because you're going to have to deny their TPR 3 years later because somebody didn't get an evaluation 2 years before. But it also is very punitive to parents because you're doing the assessment of whether they got due process at the point in time when the best interests is at most at stake. So the kids are pending adoption, they're in a wonderful place, and everything is perfect for the kids because that's when the prosecutor brings the case. And that's when we talk about whether the parent got a fair shake. We should be talking about whether the parent's getting a fair shake, but it's still obvious to even the most cold-hearted person that, or warm-hearted depending on your perspective, that the kids need to go home, right? That's when we should be talking about it. So this is the due process donut hole. I'm going to skip some of the case plan development. How does it play out in practice? So we have a bunch of hypos. I want to get to the hypos because these are interesting. These are the things we want to look at in the laws. So, the case has been in care for 8 months. The parent's housing situation does not, in fact, appear to pass a home study. Maybe they're living with an aunt, maybe the place is overcrowded, maybe it's under foreclosure, who knows. But the parent has otherwise complied with all of their services. There is no safety issue whatsoever from the therapist's perspective. The child's doing well in a foster home, and your next hearing is in 3 months. Okay, who brings the motion for unification? Those of you who practice in this area will be like, obviously the parents' attorney brings it. Well, we'll get there. But does the DCF attorney want to bring a motion for unification in the situation? Well, probably not. The home study's not even going to pass. Why would they bring a motion that under the law shouldn't pass? All right, what about the guardian ad litem attorney? Well, maybe, depends on the guardian's perspective, but this has the kids doing well in foster home. Why would a guardian want to disrupt a good status quo and put a kid in a place that's going to be foreclosed? Who knows when, right? The parent's attorney, the judge, let's take the judge for a second. Will the judge like somehow magically know that this is going on? No, the hearing's in 3 months, right? This is a quirk of this system, not even a quirk, it's by design. We put a lot of due process in the hands of the judges. The judges can't go out and investigate in the field, they only know when things are brought to them. So the hearing's in 3 months, the kid's waiting 3 months. What about the parent's attorney? Well, I don't know. Doesn't seem like an extraordinary case. It's only been in for, 8 months? It's a dependency, so they probably didn't put in a lot of hours to begin with. You don't know that the home study is not going to be approved at that point. You don't have any records because the JR, the big fat packet, hasn't been given to you yet because it's too early. Setting a hearing sounds like a lot of work, and you're not even going to get paid for it anyway, probably. So, you could probably just tell your client to wait. You've got a JR coming up. We'll see how it shakes out, right? That's a bad incentive, right? We just delayed permanency 3 months for a kid who probably could have gone home, assuming we could have gotten the housing situation worked out. Okay, hypo number 2. Case plan sends a parent to a psychological evaluation and says you have to comply with all the recommendations. The psychological, follow me here, recommends a psychiatric. One's mental healthy, one is medical. Psychiatric evaluation is recommended, but the case manager never makes the referral. That happens all the time, right? Who complains? DCF attorney? No, how would the DCF attorney know? The DCF attorney's client, more or less, is the case manager who forgot to do it. So, right, so that's not gonna happen. Guardian attorney?
Yes.
Maybe.
Yes.
Maybe.
Absolutely.
Absolutely, if they caught it, right? If they caught it. We are in theoretical world. They actually have no obligation under the law to investigate that. The guardian ad litem in Florida have to visit the kid once a month, have to write a report. A good guardian ad litem is going to get the butt out there and find out. And they're going to be following everybody around. It's not required. And we're talking about instances of the law. So guardian ad litem, maybe, and I hope so, because I used to be a guardian ad litem attorney, so I have faith. Judge, maybe when it comes to court. All right, and the judge doesn't have time to read the giant packet. Parent's attorney. Who is the one person that knows that this didn't happen? DCF attorney and I guess 2 people. The parent, right? DCF attorney or DCF case manager forgot, right? Because their workload is crazy. Let's assume that. The other person who knows is the parent. What incentive does a parent have to say, hey, give me one more task? That's iffy. If the parent believes that the task will actually get them to unification, they're going to throw their hand up and say, you didn't do this work. If the parent doesn't believe it will lead to reunification, it's a bullshit task, which often they are, then they're going to keep their mouth shut. So what does this do? Well, it probably delays permanency. It might even put a kid at risk. This is not a good situation. We have a perverse incentive right here. We need to make sure that parents are speaking up. We need to make sure that their attorneys have some investment in making that happen right early. Okay, what if it's a parent getting referred to a service, and as the most extreme, the service provider doesn't provide it at all, but signs the piece of paper saying that the parent did it? Yikes. Who's going to complain about that? DCF? No, because their own service provider is defrauding them, so they're not even going to know. GAL? Maybe if the GAL actually sits in the class, say it's parenting class, sits in the class with the parent and learns and sees what they learned. That's going to be really hard to detect. Judge? No way. They just see the report that says that the parent complied with it and applauds the parent when they come through and have a good report. Parent. The person who knows that the services are bad is in fact the parent. That's who knows, because they have to sit through the thing. And I've heard parents complain about it. And when parents complain about them, what is the response from the system?
Tough.
Either tough, or you're just trying to get out of it, or, right? Because there is a parent bias, we all know it, right? So when they start trying to complain about it, it's seen as trying to get out of it. So you can't win if you're the parent. So it either puts a kid at risk because the service was not performed. And if we're assuming the services help and actually do the job they're supposed to do, then doing the service would have made the child safe. Or it delays permanency because it's going to place the child at risk, the child's going to get harmed, and we're going to have to be back where we are from square one, asking why didn't this parent benefit? Oh, there must be something wrong with them, right? And then they say, well, the service wasn't very good, and again, it looks like gamesmanship. So quantity, we'll go through it really quickly. 6 services in 6 different places in town versus 4 and 2. Who would have to bring that up? Again, the parent. The parent has to complain about that. But if the parent doesn't know that they have the option of complaining, or if it won't be seen as basically complaining again, or if it will be seen as complaining again, you have no incentive to actually bring it up. The judge can't even order specific services, mostly in Florida, that they can put a lot of pressure on the department. The gal could ask DCF to consolidate the services in one place. I don't know that they could bring a motion to get the judge to order it, though. It's debatable. All right, this one's my favorite one. All right, the parent has some characteristic that increases interaction costs for other people. All right, that's my nice way of saying the parent is difficult. Something about the parent is difficult. Case manager routinely just ignores their calls, doesn't even pick them up because really they can't deal. Right? Who complains about this? DCF attorney brings a motion for their own case manager. They don't even know about it because it's the case manager who's doing it, right? Guardian ad litem attorney, they might actually complain if the parent's not getting a fair shake, unless they agree that this parent is difficult and has earned their place, right? Attorney ad litem, obviously, I'm including guardian ad litem and attorney ad litem together. The parent's attorney, kind of the same problem, honestly. If the case manager doesn't pick up the phone, the parent's attorney might not either. The judge, right? This is the biggest, one of the biggest problems in this area, which is that oftentimes parents get terminated for reasons unrelated to child safety. Unrelated to child safety. They were difficult, they didn't have a car. The prototypical example that I use for this is the parent is deaf. They're deaf. Nearly impossible to get a deaf interpreter, right? Very hard to do, especially for all the services. You can't find a parenting class or a therapist, and it's hard to do the therapy through a deaf interpreter. So they get frustrated, the parent gets angry, rightfully so, because they're trying to get their kid back and everybody's saying, well, can't you just read my lips? Right? Why don't you try to comply with us? Right? The parents with the highest need are often the least served because it adds to your workload in a way that is not rewarded in any way. All right, external contributors, I have a hard time with that word. The stable housing issue, so the parent gets illegally evicted. Can the judge drag the landlord in and order him to take the parent back? No, the judge has no jurisdiction over the landlord. Can the DCF attorney sue anybody? No, they're prosecuting a child welfare case, not an eviction case. The parent's attorney, they could actually represent the parent in the eviction case. They could, if they got paid for it. And so you'd have to get attorney's fees, which we don't provide through the child welfare case, even though that kind of feels like a child welfare issue to me. The landlord, who the family is living with, kicked them out illegally. Why is that not a case plan task? The landlord needs to do X, Y, Z. Oh, well, jurisdiction, right? We say jurisdiction. So we probably need to fix that. That landlord needs to feel the burn. All right? The big problem in this area is that we assume that all the problems are centralized and localized and privatized into the parent. Into the parent. And that is not always the case, right? So permanency gets delayed for a thing outside the parent's power. Doing okay?
Yeah, 5 minutes.
5 minutes, good. I'm working on it. All right. The last one is, why can't we sue every state agency in a dependency case? Why can I only fight with DCF when I actually need to fight with ACA, the Medicaid agency, most of the time, because they're not providing anybody any Medicaid services, right? Right? I have to file a class action. I heard it in a moment. How expensive is that for the attorney filing it? Incredible. Right? Why can't I just drag an ACA or APD or whoever else into the room and get it done? Like I should be able to. All right. So here's the problem with the donut hole in the middle. We push a lot of things on the parent. We expect them to do a lot of things. When they themselves identify problems, we give them no procedural or substantive ways to complain about it without getting shot down or harmed by doing it. We focus all of our attention at the TPR level, and yeah, we're doing a really kind of crappy job in the middle. So why haven't the third-party monitors worked? Well, guardians ad litem do a very good job at advocating for the kids, not always a great job at advocating for the parents. Again, because of parents can be difficult, it can be scary to work with them, there's a lot going on there, maybe the guardian doesn't actually have the level of expertise to know whether a therapy service is appropriate or not. The review committees, if you have any of those, death review being the statewide one, the biggest, doesn't actually see every case. Yeah. So let's skip that. What we want to do is reimagine, this is what I'm hoping to do one day, actually reimagine the middle part as now that a parent is in the child welfare system and they've been adjudicated, the children have been adjudicated dependent, the parent is actually the prosecutor through that portion of the case. I want to pay the attorneys enough or do whatever I have to do where they feel as though they are the ones running the show. You gave me a case plan that says I have to do the following. All right, wonderful. You believe that this will help me. Wonderful. Then why is it 3 counties away that I have to do it? Why can't they bring their class action in the context of the child welfare case? Why can't they bring their federal lawsuit, their ADA claims, their everything else, right there in the middle in the context of the child welfare case? Oh, because it will disrupt the entire system. And my response to that is, it will disrupt the entire system. And that is what we want to do, right? Because what we have now is not serving children, one category of children very well. The parents that get through it easily are served fine. They didn't even need to be there with all this court oversight because they just skated through it. All they had to do was show up to some classes. Maybe they needed the fear and the scare tactic at the beginning of the shelter, but otherwise they did it. And then the parents with the extreme problems, the problems for which no services will help, which are not the parents we're talking about, the ones that we started off with, fine. They're actually pretty easy too, because we can TPR them pretty quickly. It's these kids in the middle, the parents that have difficult problems that make everybody kind of stress out and not want to work with them, that's the ones we need to focus on. The ones that require a lot of effort on the part of the state is where I want to get us to. So how are we going to do that? I don't actually know. I have some ideas. We would like to incentivize, well, we would like to actually make there financial penalties and penalties in general at the beginning for the state not complying. We would like to incentivize early reasonable objection efforts. There's a lot of models for doing this, I can imagine, like making you actually have to preserve your reasonable efforts objections during the dependency. You cannot bring them up at TPR. If you didn't preserve them, you give somebody an opportunity, kind of traditional evidence style. You didn't raise it early, you can't bring it up later. That will cause a lot of problems because then you're going to be chasing problems early, but you're going to have to restructure your entire hearing structure because you can't do 15 to 25 JRs all at once if you do it that way. We want to give parents, I learned this from a parent's attorney, and it may not be true everywhere. We want to actually give them social workers. In fact, the social workers should probably work for the parents, not the other way around. Why? Because they need somebody they can trust, they need somebody they can talk to, they need somebody who picks up the phone and is paid to pick up the phone for them. Not paid to pick up the phone for a caseload, but literally is paid to pick up their call. And that's not happening, right? So giving them their own social worker, we'll call it a mitigation expert type thing. Jack, from my understanding, won't pay for this yet. But we're gonna try to, maybe they don't understand what it is. So we're gonna work on that. Jack is the agency that pays for these things. I would love to see attorneys in the child welfare system get attorney's fees for doing the ancillary things to a child welfare case, just like the attorneys for the children now get, right? I'm a child attorney. If I get on the special registry and I go out and need to do education advocacy, I get to do that because, and I get paid for it, right? If I need to sue APD for that kid, I get to do that and I get paid for it. Why can't the parents' attorneys have the same benefit? To fix the things on behalf of the parents that don't necessarily, or can't necessarily be brought in the name of the child. I want to be able to sue every state agency all the time. In one case, in front of one judge who likes me. Like, that's what I want, right? And we have other ideas, but we'll let it go. See what we're done. Think hard about this. When Robin got the question from the Florida Supreme Court about, well, how possibly could the rights and interests of the parents be aligned with the rights and interests of the children? That question was asked, I think it was asked genuinely, and also as a pushback. How could the parents possibly be aligned with the children in TPR, right? And the question tells you a lot about where we are right now, but it's not even conceivable. So I hope that those of you who go into child welfare work, those who work in it, will start thinking of the parents as the best advocates, the ones who are involved and are fighting. And the fact that we get nowhere with them and that they feel so helpless is because we have created over the years a system for themselves. So I thank you very much, and